I want to introduce today's keynote speaker, Dr. Anne Cavoukian, Executive Director of Privacy and Big Data Institute, formerly the Privacy Commissioner here in Ontario. You will have read her absolutely incredible biography. You might even have seen her on Metro Morning here just the other day, and maybe about a month ago on the National. She was like, we're in the presence of like TV royalty here or something like that. It's fantastic. Dr. Cavoukian, Anne, will share her expertise in how to avoid disputes over privacy and building on the dispute resolution process, how to resolve disputes over privacy without having to go to court, which I believe we here in this community feel is a preferred model. Dr. Anne Cavoukian is recognized as one of the world's leading privacy experts, appointed as the Information and Privacy Commissioner for Ontario in 1997. Dr. Cavoukian served as an unprecedented 3 terms as Commissioner. There, she created Privacy by Design, a framework that seeks to proactively embed privacy into the design of technology, infrastructure, and business practices, thereby achieving the strongest protections possible. In October of 2010, a conference on international privacy regulators unanimously passed a resolution recognizing privacy by design as an essential component of privacy protection. Since then, the project's been translated into 38 languages. In her leadership at the Privacy and Big Data Institute at Ryerson, Dr. Cavoukian is dedicated to demonstrating that privacy can and must be included along with other considerations such as security and business interest. Her mantra, banish zero sum, enables multiple interests to be served simultaneously. Dr. Cavoukian, Anne, would you please join me up here, and would you please join me in welcoming her to the platform?
Good afternoon, ladies and gentlemen. It's such a pleasure to be here. I'm just honored to be with you today. And I'm going to be talking to you about, and I really don't want to bore you, but I think it's so important to get a sense of what's the background of privacy, what does it mean, and more importantly, what does it not mean? And then I hope to tie that into your area a little bit, but I have certainly no expertise in your area. The one thing I should point out that I was mentioning, that when I was commissioner, even though I had order-making power, I always tried the approach with the carrot instead of the stick. I always tried to resolve things informally through a variety of things. Mediation was extensively used, and we had much greater success, in my view, when we could use informal resolution instead of order-making power. Now, sometimes you have to use the order, and it was wonderful to have it, but it was only a last resort. So I have great respect for the work that you do, and I want to tell you a little bit about what I do. Okay, so I'm going to be turning my shoulder to make sure I see what you're seeing. Privacy is all about, started with, it's called Fair Information Practices. Big term, simple concept. There are 8 principles in fair information practices. They first emerged in 1980. They were revised, very minor update, in 2013, just a few years ago. And the essence of it is that you restrict the information you collect for the intended purpose. When someone gives you personal information, if they give it to the government or to a business, they don't give you information to do whatever the heck you want to do with it. No, they give it to you for a particular purpose. So the notion of purpose specification and use limitation, those are really critical. It means you collect information for a particular purpose, you restrict your use of that information to that purpose, and if you want to use the information, the personal information, for additional secondary uses, then you've got to go back to the individual, often referred to as the data subject, to obtain additional consent. If that was done, you wouldn't need privacy commissioners or privacy experts or anything like that. But I assure you, that is not the norm. And my job has been to try to get people to embrace this model. And I'll show you something that I developed, which has been working quite well. These are just the 8 principles for your information later on if you want to see what they look like. Forgive me for turning my head all the time, but I want to make sure I'm talking to the same slide that you're seeing. Now, I always like to start by dispelling some myths, because myths proliferate, and I want to make it very clear what privacy is and what privacy is not. Privacy is not about secrecy. It's not about having something to hide. No, I'm sure you've all heard the wonderful expression, well, if you've got nothing to hide, what's the problem? You've got nothing to fear, right? Wrong. That, I always said, should have been the motto of the Stasi police in Germany many years ago, because that's what it's premised on. It's not premised on freedom. It's not premised on democracy. It's premised on that the state has the right to know everything about you. No, they don't. Last time I looked, we still live in a free and democratic society, and we hope to preserve our freedoms. In order to do that, you must preserve your privacy. Privacy equals control. It equals personal control relating to the uses of your personal information. See, if you're a law-abiding citizen, you get to decide what you want to do with your personal information and to whom you wish to disclose it. That sense of personal control by the user of the info is very, very important. It hinges on freedom of choice and context. Context is absolutely critical. I can't emphasize that enough. And I often use myself as an example to really drive that home. The individual will know things that only the individual will know, which will guide their decision as to whether they want to disclose the information or not. And the example I often give, in 2004, Ontario introduced a wonderful bill, which is now law, called PHIPA, the Personal Health Information Protection Act. And it is outstanding. And what I do, whenever there's a bill being introduced by the government that I support and that I think is great, I go around to the stakeholders and I talk to them extensively about the benefits and the assets of this bill and how important it is to pass it. 2004, I did this with stakeholders, hospitals, doctors, etc. And to my surprise, after the second or third time, I could tell I wasn't getting through to the audience. Usually I get a good response from the audience, I have questions afterwards, and there's a good exchange. I was just getting a wall, and I didn't know why, and it was too important an issue. This was an excellent privacy bill. So I think midway through my third talk, I just stopped, and I said, please, would you kindly tell me what I'm doing wrong? I'm going to stop now, because I can tell I'm not getting through to you, and that's my fault. I need to correct this. Please help me. What am I doing wrong? And some fine, young, enterprising doctor stood up, and he said, look, you're probably a good privacy commissioner, but you don't know what it means to be a patient. You don't know, and I got it. They thought I was talking just as a privacy commissioner and putting privacy above the needs of patients. You see, that model of zero sum, either or, one interest prevails, the other one doesn't. It just is embedded in our society. So I got it, and I made a decision that no one else could have made. My doctors, I assure you, never, ever share my health information. But I decided it was my choice, and it was so important to me that this law get passed and people understand that. So I said to the guy, I said, are you kidding me? You think I don't know what it means to be a patient? Do you know how many neurosurgeries I've had? Brain surgery? They shave your hair off, you go in, you feel like crap, you look even worse. I said, do you know how many times? I've had about 5, maybe 6 surgeries. I'm in and out of the hospital, and I can tell you, I have been to emerge many times where my head is exploding, and all I want them to do is take the pain away. I'm not even thinking about privacy. And the poor guy, his jaw dropped. And I thanked him profusely, because if he hadn't told me that, I couldn't have shared the information, which was to let them know I knew what it meant to be a patient. And nothing is more important than the delivery of healthcare services. Addressing the patient's needs always comes first. I said, but what if I can give you that and wrap a cloak of privacy around it? What if I can give you both? Wouldn't you rather have that? And everything changed as of that moment. They understood I knew what it meant to be a patient. I wasn't elevating privacy above the needs of patients in healthcare. I was offering to make sure that healthcare came first and privacy went with it. And once that happened, everything changed. The bill flowed, everyone applauded it, and everything changed. But you see, no one else could have imparted that information other than me. That's why context is so key. The individual will know things that they will be able to make decisions on that no one else can. I often go to social functions, receptions and things, and some of my docs will be there, my neurologist, my neurosurgeon. I love these guys. And so whoever I'm with, I'll say, oh, let me introduce you to my neurosurgeon. Let me introduce you to my... They will not utter a word admitting that they are my doctors and that they've ever done anything for me, because they are amazing in terms of wanting to protect my information. They go to such lengths, and that's why I want you to understand how important this is. privacy is not about having something to hide. It's about making the decision whether you want to release some information or not. I always tell people, privacy is not a religion. You want to share your information? Do so. That is your right. But do so with some understanding of the consequences that could arise, especially in the context of social media and freely sharing information in ways that might come back to bite you. Okay, let me talk to you about privacy by design. As was mentioned earlier, privacy by design was unanimously passed as an international standard in 2010. I was really amazed that it was passed in that manner. Once a year, privacy commissioners have a privacy conference, usually in Europe. In 2010, it was in Jerusalem. And at the end of a 3 or 4 day conference, we have a half-day closed session where commissioners introduce resolutions that are voted on by the entire assembly. And this year, I introduced privacy by design. The intent of privacy by design is to complement regulations. You see, regulations are wonderful, but they come after the fact. There would be an investigation. When I would receive a privacy complaint, I would investigate, and then I would offer some system of redress, a remedy, after the fact. Very important. But I wanted to put something at the front end proactively to try to prevent the privacy harms from arising. Think of a medical model of prevention. You would never, go to your doctor and he says, yeah, I see you've got some cancer developing here. We're just going to see how it develops, and then if it gets worse, we'll offer you some chemo. I mean, what an unthinkable proposition. I wanted it to be equally unthinkable that you allow privacy harms to develop and then deal with it after the fact. And what surprised me was that this was unanimously passed, and then I got it afterwards. The essential importance of privacy by design was that in an era of ubiquitous computing, online connectivity, social media, wireless and wearable devices, massive expanse of data being circulated, we realized as commissioners that it just was no longer possible to address all of these issues. I often use the iceberg example, that we as commissioners felt if we were seeing the tip of the iceberg, we were lucky, that the majority of the privacy harms were remaining largely unknown, unchallenged, unregulated. We just couldn't get to them all. We didn't have the resources, we didn't have the capacity. It was escaping our detection. And for us, that was not acceptable. So privacy by design was introduced in an effort to complement, in parallel, regulations which were after the fact, but that we now knew we had to do both. And was also mentioned earlier, we've had great success. It's been translated into 38 languages, and it really has a global presence. And not a week would go by when I was commissioner when I wouldn't hear from some jurisdiction about what they had done in their jurisdiction, relating a new story to me or a new case. It was just so gratifying. And what I love about it is the two essentials of privacy by design is that you're proactive, you do this right at the outset. You embed privacy protective measures into a new program you're introducing, a new system, a new business practice, whatever it is. You do it right from the beginning. And that minimizes the likelihood of the harm because you're identifying the risks and addressing them. But the other second essential is what I referred to earlier. I want you to get rid of this either-or proposition of a zero-sum mindset. Zero-sum simply means that you can only have a positive increase in one area, security, always to the detriment of the other area, privacy, such that the two total to a sum of zero. In my world, I can assure you, it was never privacy that won over some other interest, and nor should it be. But I also would never accept that it has to lose. So the whole concept of getting rid of zero sum and substituting what's called positive sum, which just means you can have two positive gains in two areas at the same time. If you want a shorthand, think win-win. You can do both. And I tested this with many different colleagues, but I especially tested it with computer scientists, cryptographers, technology experts, because I wanted to make sure what I was saying was doable to them. I always said, bake it into the code that you're developing. Make it an essential part of the data architecture. And I've spoken to hundreds and hundreds of engineers and securities people. Every single person, when I said, can you do this? They said, of course we can do this. We're smart. I love that confidence. You've got to have confidence. But they said the problem isn't us. They said we rarely get those instructions when we're given the instructions to write the code. We get instructions, we deliver the program, and then when we give it to them, they say, oh, could you add on a privacy solution and bolt something on after the fact? And they say, give me a break. You know, we can do something, but it will rarely be that effective. If we'd known at the beginning, we could have made it an essential component of the structure. So then after I learned this, I went around talking to CEOs, boards of directors, senior executives, and said, get rid of the silos. Get rid of it. You've got to have one message that reflects many different aspects when you go to your engineers to develop a program, for example. The lawyers have to talk to the policy people, have to talk to whoever is involved in the particular area. Everyone has to share this message and then get that to your engineers, your software designers, etc. So we've had great success with this. I'm going to walk you through what are called the 7 foundational principles of privacy by design. They are literally meant to be foundational. They form the basis of all that we do. And then the actual program will look 100 different ways, depending on your area and how you do it. But it just forms the base. I've already touched on a number of these, so I'll go through it quickly. Being proactive and trying to prevent the harm, absolutely essential. Let me refer to privacy as the default setting for a moment. That is absolutely critical, because what that says is, instead of expecting the poor individual to go through the terms of service, which are 20, 30 pages, go through the privacy policy, which is full of legalese, to find the checkout box that says, I only want my information used for this purpose, don't use it for any other purpose, opting out of the use of that information for secondary purposes. The reality is we know nobody does that. Very few people do that. I no longer do that. I admit it. I mean, life is short. And everybody is so stretched. You know how many things you have to do? I am glued to my computer. And in the evening, it's terrible. I mean, I have the best husband in the whole wide world. And of course, I'm having dinner with him, an evening, watching a show or something. And I'm trying not to look at my iPhone and the latest tweet that's come by or whatever, because the stories break like this. Everybody's busy. We get this. But the obligation should not be on the individual to frame their privacy. The obligation should be on you. Privacy is the default, meaning that you as an organization, private sector, public sector, doesn't matter, you tell the individual you're collecting information from, don't worry, I offer you privacy assurance from the beginning. Privacy is embedded into what I'm asking you to do. I will only use your information for the purpose I intended that it was collected for. I won't use it for any other secondary purposes. And if I want to, at a later time, use it for a secondary use, I'll come to you and get consent. It raises the bar dramatically. It's an opt-in model of privacy, positive privacy, and it raises the bar dramatically. And in a moment, I'm going to tell you about a new law that has just been passed in the European Union that actually has privacy by design and privacy as the default in the statute. This is a first. It's huge, and it's going to really shake things up. But just in case you think, it sounds good, but this is like some kind of academic construct or a theoretical formulation, let me assure you it is not. It's real. It's on the ground. It has to work. Otherwise, I could never have done this in my previous role. At the end of 2012, we put out a paper, which is actually a compilation of 22 papers that we did at the Privacy Commissioner's office. And think of any major tech company, Microsoft, Intel, IBM, HP, Oracle. I know I'm leaving some out. We did 22 papers with these companies on these areas that you are seeing here, because we wanted to show this was doable, that companies saw the benefit of doing this because they get a real positive return from it. It's like they gain a competitive advantage by offering this to their customers. And especially after Edward Snowden's revelations in the last 3 years ago, everything has changed. Public distrust is at an all-time high. People have much greater expectations of privacy, and they're asking companies, what are you doing with my information? They want to be assured that the government isn't just having, wide access to this in ways especially that are not transparent to them. massive kind of surveillance that was underground. And just think of Yahoo, the most recent example with what's happening with Yahoo, and it's going to impact, it already has impacted their purchase price by Verizon, who asked for, I think it was like $1 billion discount, if you can believe this, after all these revelations. This will come back to haunt you, both as a business and as a public sector entity, where trust is essential and is lacking. These are some of the points you have to consider. The other thing is, and I'll never forget, in Ontario, we did a lot of projects on smart meters and smart grids. In Ontario, smart meters were mandated by law a number of years ago. You had no choice. You had to have a smart meter put on your house. So I remember I went to the Premier at the time, Dalton McGuinty, and I said, Mr. McGuinty, you know, you can pass whatever law you want, but I have a problem with this law because of the potential for unauthorized access of the wireless information flowing. I said, would you allow me, my office, to develop really strong policies as to what companies should do? He said, sure, I'd love that. So Toronto Hydro, Hydro One, we worked with all of these carriers to devise very strong ways that the wireless communications would be encrypted, would only go from the sender to the receiver, no unauthorized access. We went to great lengths to do this. And we've had great success. We haven't had privacy-related issues with these wireless smart meters. I got a call shortly after our papers, and we did about 6-7 papers on this. Got a call from San Diego Gas and Electric, and they said, you know, we've read about the stuff you're doing. We'd really like you to come and talk to us because we're having a lot of problems. In California, the smart meters were not mandated by law. Companies, electricity companies, etc., wanted to put them on houses because there were advantages to using this as opposed to the old-fashioned ways. But in California, the people were very opposed to this for privacy reasons, a number of other reasons. And they told me the story that when their trucks went into one particular neighborhood to install the smart meters, their entry was blocked. Residents on the street, they got their cars and they put it at the front to block the entry of San Diego Gas and Electric. I mean, it was amazing. It was very clever. But anyway, it was a real problem for everyone. So they said, come and talk to us about what you had proposed. We'll see if it can work here in California. So I went and gave my pitch. And we had a really good exchange. And at the end, it was the CEO or one of the executives on the board. He said, okay, young lady, I get that. And he said, at least call me young lady. That part was really good. He said, now, young lady, tell me what this is going to cost me, just like that. And I said, with great respect, sir, you're asking the wrong question. You should be asking, what's this going to save me? Because I can assure you, if you don't do this, you will have unauthorized access of some method. You will have a breach. You will have a lawsuit. It will probably grow to a class action lawsuit, which is what is happening all over the United States and now in Canada, and you want to avoid that. So, yes, while there is a minimal cost at the front end to engaging in this program of privacy by design, the cost is a fraction of the costs you will incur when you have a data breach. And it's not just a matter of, as I said, lawsuits. They're class action lawsuits now. But the damage to your brand and to your reputation can be far greater. It can be irreparable. That's what we've seen. Loss of consumer confidence and trust means that your customers can walk out the door. The costs are astronomical after a breach compared to before. So get smart and do this proactively. They did. They signed up, and touch wood, they've not had any problems. And the other thing I say is, if you do this, if you follow a privacy by design methodology, don't keep it to yourself. Shout it from the rooftops. Tell your customers, tell your citizens you're doing this, because there will be great returns that will benefit you. One example, I used to have lots of people write to me. Japan was an early adopter of privacy by design, and just before I left, they wrote me a letter, which I love because it said that their private sector insisted on the principle of positive sum, not zero sum, and had become enlightened with privacy by design. And I thought, if the Japanese can understand the concept of positive sum, and it's not their primary language, then surely we can embrace this methodology here. And we've had great success with it. Now, I mentioned that I was going to tell you about this new law. It's called the General Data Protection Regulation. It was just passed this year in the European Union. And it's a major development for two reasons. First reason, for the first time ever, they're going to have one overarching privacy data protection law that will be replacing the 28 separate privacy laws that the 28 member countries used to have. Sorry, 27 now that the UK is out. But who knows what's going to happen with the UK. But they say they're going to follow GDPR anyway. So, but anyway, the 27 separate laws, all gone, being replaced by the GDPR. That's huge in and of itself. The other development, and it will come into effect in 2018, so people have an opportunity to prepare for it. But the other significant part is that for the first time, it has the language of privacy by design in the statute, data protection by design, and privacy as the default. Having privacy as the default in a law is unbelievable because it dramatically raises the bar, and it will be so significant. The United States, in the past, I say in the past because I don't know that we're going to be able to meet the requirements of the GDPR, but in the past, Canada met the requirement that it had adequate protection to the previous law, the EU Directive on Privacy and Data Protection. The United States could not meet the adequacy requirement, so they put in something called the Safe Harbor Agreement, which meant that companies could voluntarily subscribe to Safe Harbor, which was a set of principles which would make them compliant with the former previous privacy law in the European Union. Unfortunately, for the U.S., that Safe Harbor Agreement was invalidated on October the 6th of last year. Once Edward Snowden's revelations and the consequences of them in terms of massive surveillance of citizens was discovered by the EU, there was a court challenge of Safe Harbor saying, you can't say that the U.S. protects our data the way the EU does. Look at what the NSA has been doing with their information. So it actually succeeded the court challenge, and it was invalidated, the Safe Harbor Agreement. So the U.S. and the EU have been frantically trying to replace that. There's something called the Privacy Shield, the EU-U.S. Privacy Shield, which has now been introduced, which may, I say may, succeed, but it's questionable because it has also been challenged in court recently as a result of, not only as a result of what was discovered with Yahoo and the access that the government had, unbeknownst to anyone, to everyone's subscriber data, there is just very little trust in the EU of what's going on in the U.S. So stay tuned for that. But in the meantime, U.S. companies are scrambling and saying, well, what are we going to do to be compliant? Or we want to continue doing business, obviously, with the EU. And I didn't say this, but Information Age wrote an article on this last September, and they said, it's not too much of a stretch to say that if you've implemented privacy by design, you've mastered the GDPR. I would not be so bold as to say that. However, it is true that I have been contacted a lot by companies in the U.S. who are just saying, let's do privacy by design. I want to do privacy by design. I want to make sure I get it right so that at least the EU can see that we are trying to follow suit and prepare for the GDPR. And one thing we've done, not directly as a result of that, but when I started at Ryerson, we've got a new privacy by design certification program that is really growing now. And I've partnered with Deloitte because I don't have the staff to go out and audit what companies are doing or, look under the hood, if you will, to ensure that they're following the principles of privacy by design. I've worked with Deloitte in the past. They're great. They get it. So when a request comes in to me at Ryerson to engage in certification for privacy by design, I take it, I send it to Deloitte, authorize Deloitte to go visit the company and ensure that the product or service that they are trying to get certified actually complies. And then they give me the report and I issue the certification. So it's well underway, and now it's beginning to really take off in the United States. So it's one measure of increasing privacy, which of course I favor. Okay, accountability. Obviously, it's very, very important to have accountability. And as I mentioned, I was always a big fan of mediation and striving to engage in informal resolutions in the work that I did in the context of investigations and various matters when I was Privacy Commissioner. I always felt that it was far, far preferable I use the language of using the carrot to the stick, the order. That was there. I didn't want to use it. And when we could resolve things informally, everybody was happier. Everybody bought into it, as opposed to me making them do something, which was not, nobody wanted that. So we had, I think, great success with informal mediation. The majority of our cases were there. But one thing that was so important is holding governments accountable. We really believe in this. Openness and transparency, is so essential to our governments, to citizens in free and democratic societies. And you have to have access to government records in order to ensure the kind of openness and transparency and accountability that is absolutely essential if we wish to preserve our freedoms. I love this is one of my first bosses, was the Honorable Ian Scott. He was Attorney General many years ago. And he said, I love this, "We do not and never will accept the proposition that the business of the public is none of the public's business." I love that. It just drives it home. And I can't tell you the number of times I've said this to governments, but also to private sector companies in terms of when they collect your personal information. Sometimes I encounter organizations that think that because they've got the data, they've got your data, it somehow belongs to them. And I always say to them, you do not own the data. You may have custody and control over that data, but with that comes a very strong duty of care. And you must be open and transparent with the individual as to what you're doing with that information. It's absolutely critical. This takes me to open data in the context of government accountability and openness. There's a big movement now on open data. It's getting a lot of traction, which is absolutely great. Again, the one thing I like to remind people in this era of big data and open data is feel free to use data analytics. There are so many valuable benefits that arise. Feel free to be open with your data assets. Absolutely critical. Government-held information, government-held records, etc., should be accessible to the public. Push it out. Don't expect them to make requests. Just push it out very openly. What you do not push out is personal data. If your data, and I'll talk about government organizations right now, but if you are holding personally identifiable data, you don't put that out in the public. That's not what open data means. Open data relates to the records of the government, variety of policies and procedures, and a ton of information. And if you do want to release some personally identifiable data in terms of aggregates, where you've removed the personal identifiers, you've gone to great lengths to minimize any risk of re-identification, you can also do that too. The privacy harms begin and end with the identifiability of the data. If you can eliminate that, then you're golden, and you can do whatever you want after that. It's really, really important to create open data structures that are readily accessible in terms of being machine readable, friendly in that manner, and licensed to permit free reuse. So these are some of the concepts that I try to bring to organizations that use whatever means you have available to engage in resolving of disputes and alternative options. But take care that when you're engaged in the discussions, that if there is some personally identifiable data, that all the parties have consented to the sharing of that data in the dispute resolution model, and if not, use other means. It's the identifiability of the data that renders the harm, and it can happen inadvertently. I've seen this happen so many times. I tell companies, once you've received personally identifiable data and you've used it for the intended purpose, don't retain it in personally identifiable form, even within your organization, because the majority of data breaches result from, I call them inside jobs. I don't mean that some of them are fraudulent, but most of them are just mismanagement or problems with keeping the data. Save yourself a lot of trouble and strip the personal identifiers, or better still, if you don't need the data anymore, destroy the data securely. If you can think of these processes in the context of privacy by design, it's all about embedding these protections automatically into what you do, so that it's not an afterthought. It's part of the process. It becomes a seamless part of what you're doing in the context of privacy. And my devotion to positive sum and my abhorrence of zero-sum models is simply because the either-or model is a crippling model. And I work, believe it or not, with law enforcement all the time. And you might think this is at odds. It's not. It's just reframing it in a certain situation. I'm sure, I'm going off track here, but I'm sure you've been aware of the Apple versus FBI discussions relating to access to encrypted data. I mean, Apple has gone to great lengths to offer end-to-end encryption to its customers because they don't want to have your data. It's just too sensitive an asset to rely in their hands, plus the possibility of data breach, unauthorized access. Everything grows when you possess this information, which you shouldn't have. And whenever I talk to law enforcement, I've done a lot of these, I want law enforcement to get the information they need, but there are a million other ways to get this information. Now, James Comey's comment about going dark, it's nonsense. The leading cryptographers in the world got together and have responded to that. And there was another paper that they developed called Don't Panic, which was intended for the law enforcement community, showing that since the advent of the Internet and World Wide Web, the amount of information available to you automatically is 10 times what there used to be. And then if you follow the leads, it will take you where you need to go. So those are the areas that we try to develop with them. But forgive me, I digress there. I urge you to consider privacy by design if you can embed it into your operations, and I'd be very glad to answer any questions you have. Thank you very much, ladies and gentlemen.